Your Honor, opposing counsel, ladies and gentlemen of the court and jury, today we are here to answer one question and one question only. Was my client guilty of first-degree murder? And as I described, we had a filter, something that was to move the ignorance and the foolishness away so that there could only be truth. And for my client to have been guilty of first-degree murder, one, she had to be of, like she said, sound memory and discretion. But not just one element, two, and we know that she had to give reflection, consideration, premeditation, and the law states, and I'm going to quote the law verbatim, it says, turning over in thought, giving second thought. No place in her testimony did she say that she considered option one, I might kill him with the gun, or I might stab him. Remember, it says in the dictionary that she might turn more than one option. She only considered one option. So when we look at the key element of premeditation, and we look at consideration and reflection, we must look at, did she have more than one option? However, we will stand firm that she acted in self-defense. Why? Because the law states that one, she had to be in a situation that she had reasonable belief to know that her life and that of her children were in imminent danger. You're telling me that when you are beaten, battered and bruised, beaten like a dog, that you are not in imminent danger? That he just said, bang, you're dead, you and those two brats, you're not in imminent danger? You know that from past experiences, that when he said he was going to beat you, he woke up and beat you. But we're not just saying that she rationalized this because she was in sound mind, but because she was a battered woman and suffered from battered woman syndrome. And the elements of that states that she felt helpless. She did not feel like there was a way for her escape. Thus, she had to do what was necessary in that exact moment. One, she was financially dependent on her husband. She did not have a job. Two, she felt as if her life was going to be taken if she left. And three, she was isolated from her friends and family. And because we have set up the facts, we have not come here to see if she was judge or jury or executioner. We've come to see if she was guilty of first-degree murder. And because she doesn't meet element one or element two, I hope the jury, the judge, and each one of you guys today come to the conclusion that my client acted in self-defense when she went up there like a mother, who was a nurturer, who was a lover, and who was a defender. Thank you.
Hello, my name is Anton Dormer. I am the lead attorney for the defense. This case was about a woman named Dominque Stephens who has been abused by her husband for a number of years, and she just finally got fed up to the point where she went and killed her husband. But due to battered woman syndrome that she sustained, she had learned helplessness. And due to this condition, she was unable to really think rationally about going and killing her husband. So we believe in the defense tried to prove that she acted in self-defense due to battered woman syndrome against what the prosecution has stated to be first-degree murder by premeditation.